rich businessman, it seems that you can have access not only to the finance minister, but to the prime minister himself.
Justin Trudeau defends the Liberal Party's fundraising methods. He faced more criticism today for attending an event with a wealthy businessman who later donated $1 million to a foundation named for his late father. For more on the controversy, we're joined by Lauren Huser. She's a lawyer and an editorial fellow at The Walrus. So, Lauren, nice to see you.
Thanks, Andrew.
What do you see as the main issue here?
Sure. So this is really about ethics and the perception of ethical conduct among the highest decision makers in government. And at both the provincial and federal levels of government, there are ethical codes of conduct and then ethics laws that govern the actions of public office holders. And under the Federal Conflict of Interest Act, there is a requirement that public office holders, which includes the Prime Minister, cabinet ministers, parliamentary staffers, advisors, it precludes them from placing themselves in positions of actual conflicts of interest. And that is a situation where situations where their exercise of decision-making powers are compromised, or there's reasonable concerns about them being compromised by some personal interest to advance their own interest or that of friends or family.
So let's look at what's happened here. Do you think that that could be the case?
Well, I think this is more likely a situation of apparent conflicts of interest. And one of the issues with the Conflict of Interest Act is that it does not currently prohibit apparent conflicts of interest, which is a situation where you don't have in fact a conflict, but reasonable observers looking at the facts would have suspicions as to whether a decision was made for the right reasons. And the Supreme Court of Canada has said apparent conflicts of interest matter as much as actual ones, because if the goal of ethics laws are to instill public confidence in decision-making by government officials, it doesn't matter if you don't in fact have a conflict if everyone believes you have one.
So this is where I'm wondering. So if the Supreme Court has ruled that, then are you saying that a law may have been broken?
And I'll clarify, the Supreme Court hasn't ruled that. It has just simply, in a decision called the Queen and Hinchey, said that these apparent conflicts matter as much as actual.
They matter as much. So it doesn't mean that a law has been broken.
No.
It just means that they matter as much.
No. But there is the 2010 Oliphant Commission and numerous legal experts have said that the legislation should include a standard that prohibits apparent conflicts. And BC has legislation like that in place, and that has proved manageable to enforce. And so one of the challenges with this current Cash for Access fundraiser that's most recently been in the news is questions around, did the payment of money to gain access to this event possibly influence either the decision to approve a bank, because one of the attenders was or is the founder of a bank that was received final approval just days after, months after the fundraiser. And then, like you've mentioned, a separate guest who attended the event is a Chinese political advisor, and he donated a substantial amount of money to a foundation that is obviously affiliated with the Trudeau name at the very least. And so it may not, in fact, affect how Trudeau or the government makes decisions, but people being aware of these facts could have questions about whether decisions are impartially made.
So you think, because what's interesting about this is that the Prime Minister has his own ethics rules that he's given to his ministers that would include apparent conflict of interest. They do include apparent conflict of interest. So what does it suggest if he's breaking and his ministers are breaking their rules? Well, it's not law. They are directives.
Sure, and that's one of the challenges. That's why experts and the Oliphant Commission have said this should actually be in law. This should be a requirement in the Conflict of Interest Act, not merely in an ethical guideline. Because one of the challenges with that guideline, it's called the Open and Accountable Government Rules, is that they're not legally enforceable, and then they're enforced by the Prime Minister's office. And in this situation, when The decision maker in question is Prime Minister Trudeau, and he's the one whose conduct we're concerned about. There's conflict in that there's a concern that those rules would not be applied by the person who's charged with applying the rules. So some people have suggested the appropriate response would be to take those guidelines and hand them over to the Ethics Commissioner, Mary Dawson, and have her enforce the guidelines. The Conservative government had put forward a motion to this effect, which the Liberals voted against, interestingly enough.
All right. Lots more on this story, I think, in the days and weeks ahead. All right, Lauren, thank you very much. And that is Lauren Hauser, editorial fellow at The Walrus.